I'm pleased to introduce another in our series of the Preserving Perspectives project of the Academic Council of the ITA. This series is recorded and the videos are made available on ITA's website. These videos of interviews of active arbitrators are preserved in this process. This is a tremendous resource for the arbitration community as well as for those with an interest.
I'd like to introduce my colleague and friend and the last immediate past chair of the Academic Council, Andrea Bjorklund, who will be helping us to continue the tradition that David saw us creating. Many of you know Andrea, who is currently the Eve Fortier Chair in International Arbitration and the International Commercial Law at McGill. And most recently, she was named McGill's Norton Rose Fulbright Scholar. Quite a coup, which is why we're lucky to have her with us. And she's been a voice of reason in thinking critically about international arbitration. She's also one of the best editors I've worked with in years, and she's generally a thoughtful and fun person to be with at Dallas. She also is a member of more entities than I can count, but I want to flag that she's also on the board of the AAA's arbitrator roster, the NAFTA 19 roster, and she's worked in the State Department and a fantastically prolific author. I was looking at her CV last night, and I didn't know she could publish that many articles in 1 year. But she's fantastically positioned with her personality and intellectual acumen to help lead us into our next interview with our lunchtime main event, Claus von Wobeser. And with that, I turn it to Andrea. Thank you.
Well, thank you very much, Susan. That's a really kind introduction. Claus von Wobeser is a founding partner of von Wobeser y Sierra, one of the top 10 law firms in Mexico. He has acted either as counsel or as arbitrator in more than 150 arbitrations. He has tremendous experience in both commercial and in investment arbitration. His remarkable career, about which we're going to hear more, has included working as an in-house counsel at major companies, founding his own law firm, and establishing the National Institute for Migration. This recitation of facts, which is really only a partial selection of certain highlights, of course does not do justice to Claus in capturing his extraordinary career. But I hope that our conversation will add texture to those words. So let us start a little bit with your family. Your name is German, yet you live and work in Mexico City. What is your connection to Mexico and to Germany?
Okay, my four grandparents were Germans. My father was born in Germany, but came to Mexico when he was 14 years old. My mother was born in Mexico, but she studied 25 years in Germany. So I grew up, they met in Mexico, and I was born in Mexico. And I grew up with a German family, in a way, speaking German, but living in Mexico. So I'm Mexican, but the German origin.
Yes, but you did some of your education in Germany, and then you shifted to Mexico.
No.
Okay.
I studied at the German school in Mexico,
okay.
But I always lived in Mexico, except for 4 years I lived in France.
And you went to law school at La Escuela Libre de Derecho. Were you interested in international law at that time or in arbitration?
I was, obviously I had very little contact with law because no lawyers in my family in Mexico. And I was interested in international law. I liked the topics, the public international law, private international law. And speaking several languages, I felt it would be an area which probably speaking languages and I like to travel. So I felt I was interested, although I didn't know much what it was.
Uh-huh. Did you encounter difficulties with your studies at all? I think you had a few challenging professors.
I had challenging professors. La Escuela Libre de Derecho is a very unique law school in Mexico. About 10% of my classmates only made it to the end, so 90% in the road failed. And it's still today, it's a very, very strict law school. So it was difficult, but I enjoyed it, and I really studied very hard because I didn't want to fail. So I was a mediocre student in primary school and secondary school, but I think at law school I really concentrated and started to really study seriously, which I think was a good thing, to be scared of not...
Scared of failing.
Scared of failing, absolutely.
And I think your thesis at La Libra was actually on foreign investment in Mexico. And in fact, you were quite influential at an early age because you saw something in the future that was important.
I was interested in that topic, and the law of 1973, which was enacted by Mexico on foreign investment, I studied that topic, and I concluded that the Congress of Mexico did not have the power to issue the law, so the law was unconstitutional. And so I wrote about the topic. My professor at the beginning was not very convinced. Mexico has the same constitution, principle in the Mexican constitution, that if the Congress has not specific powers to issue a law, that area of law is reserved to the states. And so Mexico copied that principle. So I studied the topic and I ended writing my thesis. My professor, when he finally read the thesis, he told me, "You convinced me, and I will send your thesis to a senator to see if they amend the Constitution." And so he did. So I was flattered, but I never thought it was going to happen. But yes, the Congress took the idea and based on my thesis, and they amended the Constitution precisely with the draft recommended in my thesis. So I was quite happy with that.
Pretty heady stuff. Pretty heady stuff for a law student. So what was your first job after you graduated from La Libra?
Well, I actually was working already as a law clerk. In Mexico, it's very common that during your law studies, which is 5 years, and then you have 1 year for writing a thesis, in parallel, you have a part-time job. And my first job was at the law department of UNCITRAL in Mexico, and it was a subsidiary of the big U.S. company, which was one of the top 20 companies in the U.S. at the time. And so there I started my first practice. And then I moved, from that I moved to the Goodrich firm when I became a lawyer.
Right. What did you find most exhilarating when you first started practicing law? And what did you find most difficult?
When I started practicing law, arbitration didn't exist in Mexico. So I was a corporate lawyer dealing with the M&A and some finance work. I was charged, my friend Tom Hedder, which was a colleague both at the firm, but as well, we had been classmates at the Libre Derecho. Were entrusted to do one of the first mergers ever in Mexico, which was all the subsidiaries of Motorola, which we had to merge. The partner in December went to holidays, and we had to complete the big merger, very complicated. But those challenges, I think, were very important in my life, and fortunately, everything went well. But it was challenging, but it was a totally different career. And later, this practice of having practiced corporate law was very important in my career as arbitrator, because I did many contracts, all sorts of corporate transactions, which ended up to be very useful in my practice as commercial arbitrator.
I think one of your early experiences as a junior associate did not really directly involve the law, but involved a bighorn sheep. Can you tell us about that?
Yes, that was at the time I was at the Union Carbide. The vice president of the company in New York wanted to, he was a hunter and wanted to hunt in Mexico and Baja California a desert sheep, which is quite famous. There was a list of about 500 people that wanted to get that permit. So,
and the permits were limited in number.
Very limited. There were 20 permits granted per year. So the general counsel told there was a monthly reunion with him where he assigned the projects and the work to the lawyers. I was a clerk, so they said, who wants to get this permit? So nobody was interested. So everybody said, me, but I was the youngest one, so I took on the job and went. And they told me there are 500 applications that will only give 20 permits. So I went back to my boss and said, it's going to be impossible. He said, no, you go and don't come back to my office until you get the permit. And it took 1 year. And I went every day. And I said, what need I do? And they said, no, but come in a month, we'll tell them. No. I went every day, 1 year. And finally, I got the permit, went back to the office, said, here's the permit. No, he couldn't believe it. Even though he was pushing me, he couldn't believe. So he got the permit, called this guy, and the guy said, who got the permit? Claus von Wobeser. I invite him to come with me to hunt the sheep. And so I flew up to the border of Mexico, the Mexican border in Baja California on the US side. He came with the jet. He picked me up, and then we flew down. And so I was, nobody spoke English, the whole crew. There were about 30 staff members in this hunting. So I became good friends with him, and he was a super important person in the company. So when I came back, the CEO of the company, who I had never seen, asked me to his office, and I talked with him, so I became good friends with the CEO. So suddenly everybody was jealous that I had gotten this permit. Nobody wanted to do it. And the important thing is I learned early on in my life that there's no important how small a matter is. Every matter is important as a lawyer. And sometimes the client which comes with a small case then becomes your biggest client. And I think that was really something which I learned, that every case is important, every case, and you never know if that case will bring you to the new case. So it was quite a good experience.
So this kind of leads into, you've already mentioned Tom Heather, but I wanted to ask you about mentors early in your career. Did you have mentors?
I had mentors. I had one mentor was Jose Mario Lagarza, was my first mentor at the Union Carbide. And he taught me a lot of things, but he particularly gave me trust in myself, which I think was very important. Assigned me big jobs, and after that job, he gave me more responsibilities. And then when I moved to the Goodrich firm with David Brill as well, was a great mentor. Learned from him many aspects, but not only of the law, how to deal with clients, how to promote the firm, how to, and even personal decisions. And I think I learned a lot from them, and that has well influenced me in me being a mentor of the young people, and I think it's a very important role. I have 15 partners. 13 of those partners worked for the firm and with me when they were law students, clerks, and then they became associates. Then they eventually went abroad to study, work, came back, and now they are my partners. And I think it's very important to spend time with the young people and to really dedicate time and explain to them and challenge them, of course, as well, because I think part of my bosses, what they did is they put me difficult tasks and they had confidence that I would do it, and then, of course, I gained confidence in myself, so it was very, very important.
Yeah, if I understand correctly, you were still in your mid-20s when you were heading Goodrich's Paris office. So you've talked about this a little bit, but that must have been a little bit challenging.
It was challenging. I spoke French, but not that well because I had studied in Mexico. First, the language was a big challenge because at those days in Paris, very little English was spoken. I mean, the clients I was dealing with was all in French, and so I had to jump into the water and swim. Otherwise, I would disappear. And I had to, it was a small office, there were 5 people, but I was in charge of the office. And I had to manage a budget, and I had to deal with the clients and deal with the Mexican office and with the politics. And so it was super like a master in management of a firm, which later helped me a lot in starting, when I started my own firm.
But I have a sense that you thrive on challenges, since while you were in Paris, you completed a doctorate at the Sorbonne.
Yes.
In your spare time.
Yes. I was already accustomed of working and studying at the same time, so I enrolled, and I said, I don't lose anything. If I cannot make it, then that's it, but at least I will try it. And so I enrolled at the PhD, DEA for the French in Paris, and so of course I took a lot of my personal time to write my thesis. And
what did you write on?
I wrote on my thesis was that the exchange control in France was a violation of the principle of free movement of capitals, which was enshrined in the Rome Convention of '58. And I said, how a free exchange? If I travel to Germany, I cannot change dollars, and said, what's the movement of capitals here? So I wrote about the topic. Fouchard was on my jury, and he was very mad because he said, how a German can write and criticize the French. And he went on like for 15 minutes. And I said, Professor Fouchard, before I answer the question, let me make a clarification. I'm Mexican. I was born in Mexico. I studied in Mexico. I've never lived in Germany. I've been there like 3 times in my life. So there was no question. But then he really relaxed, and I did very well. So I think he felt a little guilty that he had attacked me. So this was good for him. And that thesis later as well became in a decision of the European Court declaring the French exchange control illegal. When I wrote the thesis, nobody had written, or at least I didn't find any information on the topic at the time, and so I was very happy.
So you were a founder of the euro. So I think it's in Paris where you first encountered arbitration.
Yes, there was. I went to a program of the American Law Institute in Paris, where they had a program on the constitutionality of the Iran Claims Tribunal, and I met there Alexander Schill, a lawyer working at the Secretariat of the ICC Court. We became friends. Then he introduced me to Yves de Rance. Yves de Rance invited me to have lunch one day. He said, Klaus, why don't you go to your national committee of the ICC, and if they propose you as a member of the court, maybe the council of the ICC will ratify that. And then I said, yeah, why not? Let me. I had very little idea of what arbitration was. I'd written a few articles on the topic, but I really didn't know much. Even my PhD was international law, not really specialized in arbitration. I had read some of a little bit of literature on the topic. So then I went through that, and fortunately it worked out, and was the first member of the ICC, first Latin American member of the ICC Court of Arbitration. That's where I really started my interest in arbitration, and of course it was like an intensive course in that we had the plenary sessions where everything was decided. In those days you had maybe 10 cases per month on the plenary session, but it was a small court, and I had an opportunity to learn a lot from Yves and from the presidents of the court and the other court members at the time. So it was a very interesting introduction, and I stayed on the court for about 8 years. So even when I came back to Mexico, I was on the court, and I went frequently to Paris to attend the court sessions.
Now, when you returned to Mexico, I think you were still with Goodrich, but then you decided to establish a firm with your friend Maclovio Sierra Madero.
Yes.
How did you come to make that decision?
I was at the Goodrich firm, which was at the time the largest law firm in Mexico City, very international firm, but I felt the firm was losing clients, was still very big, but I think it was not in the right direction. I was a junior partner. I was made a partner when I was in Paris. then coming to Mexico with this monthly, every Monday partners meeting, and I tried to influence some changes. We're not recruiting good talent, and having been the top firm in Mexico, it was in decline, and after 2 years, I got ulcer because I was very worried for the future of the firm, and then I said, maybe I start a firm, and then I implement all my ideas in that new firm. Maclovio, my partner, had the same. He was at the time with the Basham firm. They offered him partnership. He said, no, I'm leaving with Klaus. We're going to start a firm. Everybody thought we're crazy, and that's where we started.
Now, was he a friend from law school?
He was
hadn't you kind of dreamed about this for a long time?
Yeah, we had dreamed about it when we were in law school. But then, when I was already partner, I said, maybe I want to stay here and influence some change here. But then it didn't work. But yes, we had discussed it while we were in law school with Eduardo Siqueiros, with Tom Header. And then Maclovio said, let's do it. And Tom was a partner at the rich firm, so he said no. And then Eduardo was at the firm with his father. He decided not to come with us, but then Maclovio and I did it and started the firm. And then Maclovio passed away in a car accident 2.5 years later, unfortunately. But we kept the name of the firm.
Haven't you maintained an association with the family?
Absolutely.
As well?
His son, as a matter of fact, the Goodrich firm, the father of Maclovio, my partner, was my partner. So then I was a partner with the son, my classmate of law school. And today, Diego Sierra, the son with 4 years when my partner passed away, is now my partner. So I've been partners with the Sierras for 3 generations.
Yeah. Quite remarkable. This is something that's a little bit off the arbitration topic as such, but I certainly don't want to lose the opportunity to ask. You were friends with Gabriel Garcia Marquez. How did that happen?
In 2001, President Fox, President of Mexico, when he won, he tried to take some people from the private sector on an honorary basis to help with some government projects. So he created committees, consulting committees. And one consulting committee was at the Institute of Immigration, which was very bad and had very many problems. So this was a body that would advise the institute and make recommendations. So I invited the former ambassador to the U.S., from Mexico, former ambassador to Guatemala, people from Red Cross, the immigration, people that had knowledge of immigration. And the idea was to have one very distinguished foreigner in the group that had suffered the bureaucracy of this immigration institute. So I wrote a letter to Gabriel Garcia Marquez, and he answered it and said, yes, I'm interested in the project. So I met with him, and then he started coming to all the meetings. We met like every 2 months once, and he would come to the meetings, and so we became very good friends. And he always made the joke. He said, he wrote Cien Años de Soledad, the 100 Years of Solitude, his most famous book, at the line of the Immigration Institute. Because it was so much time he was sitting there in their line that he wrote the book, which of course it was not true, but that's what he used to say. But he was a fantastic gentleman with very different. He was friends with Fidel Castro, and then was friends with Carlos Slim, the richest man in Mexico. So that's the type of person he was. Very simple. And all the times I saw him, he had the jacket, which was the same jacket for 5 or 6 years, every meeting of the institute. So it was a very simple, humble, but brilliant ideas always. And so it was really a treat being his friend. And unfortunately, he passed away, as everybody knows.
Yes, well. So kind of turning a little bit back to arbitration, what was your first arbitration as counsel?
As counsel was my first case, because I had cases first as arbitrator, and then people started asking me as counsel, and I had rejected several of those cases, and I got an invitation, coincidentally by Tom Hedder, who was the lawyer for Anheuser-Busch at the time, and this was about 95, 96, and there was a dispute between Anheuser-Busch, who had acquired 20% of Grupo Modelo's shares, and they got an option for another additional 30%. And when they exercised the option for the 30%, there was a dispute. There was a formula to calculate the price. The seller's calculation was 900 million, and the buyer's calculation was 400 million. So we went to this arbitration together with the Milbank in New York, and unfortunately we prevailed on the arbitration. So that's when I started doing work as counsel, and that's where we started to build the group of lawyers that today that work as counsel in the firm in arbitration matters.
So do you think, have you met very many people who've sat as arbitrator before they were ever counsel in arbitrations?
A few, but not that many. But when I did corporate work and was sitting in cases, mainly cases outside of Mexico, and then probably one of the very few corporate lawyers that moved to becoming a litigator, and today I do 99% of my work is sitting as an arbitrator or being counsel, but I sort of shifted from the corporate world to the dispute settlement. And the firm still, half of the firm still is a corporate, but that my partners take care of that. So
while you do the fun stuff.
I do the fun stuff, absolutely. I've no doubt that arbitration is more fun than corporate. Otherwise, I would be doing corporate work.
Exactly. So which arbitral award that a tribunal on which you were sitting issued has had the broadest influence?
I think probably I thought about that question, and I think it's probably ICSID Solotana, which is the president of World Duty Free, of course, from Metal Tech, where as well I was involved, which is the first case where the corruption the defense is raised, but the fraud defense in the ICSID Solotana, and clearly I think there are many cases today. As a matter of fact, the mock case this morning had the defense of the jurisdictional defense that the investment had not been in accordance with the law of the country. So that I think it's a case that has influenced many cases, and I probably think there are probably more than 20 cases that have used this case as precedent. Yeah.
Yeah, I have a doctoral student working on that, actually. And you're right, more than 20. So right now there's quite a lot of debate about whether arbitrators in investment disputes should be more concerned with developing the law or with resolving the particular dispute in front of them. Where do you come down in that debate? In my opinion, and I have a very clear opinion, I think you have to resolve the dispute. I think that sometimes, of course, some cases become famous and become a precedent, but I don't think our arbitral tribunal should be concerned with that. I think our mandate from the parties is to resolve the dispute, and I think parties would be very worried if they know that arbitrators are more concerned with creating a precedent. I think the parties are, their concern is to have a fair resolution of their dispute, and of course if a case becomes a precedent, that's great, but I never have that in my mind. I did say in the Solotana case when we finished that, what I said, this is going to become very important for good or for bad. I didn't know if it was because, and there were a few critics, and of course it was a very difficult decision whether we entered into the merits or no. And fact-driven in that particular case, which was a fraud, making the state go through the whole process in the substance was really difficult. So we really resolved that case thinking in that case, and we didn't know, and sometimes you're worried, but I think what you have to be really worried is in resolving that dispute. And if it's a precedent, that's great.
That's my personal view.
You've been involved with hundreds of cases, and you've certainly mentioned a few of them. Do you have a favorite case?
I like all the cases, and I think there are cases which some every case is different, but I think every case has something interesting. And sometimes you have a case, you say, gee, this is going to be boring, and you learn something new always. So I think I have liked all my cases. I stand for whatever has been decided, and sometimes you're not the chair, whatever is the drafting is not yours, but I think everything that is in all the awards I've rendered, I think I believe in it, I'm convinced, and getting involved in every case, even if they look boring, at the end of the day, they are very interesting. You become very passionate of each case, and I enjoy every case very much.
You have remarked, I think, that there is no recipe for success in legal practice, but rather a set of best practices to follow. And which practices would you highlight?
Well, the first practice, I think, is work very, very hard. I think...
Not a surprise.
I think there are smart people, there are more smart people, but I think at the end of the day, what pays off is being dedicated, not being overconfident. I think you have to get each case, both as arbitrator and as counsel, you have to study very hard, and you have to really, each case is different. And if you're counsel and you think this is a piece of cake, don't do that, because you never know what arguments will be on the other side. So be humble, be modest, work hard, prepare for the hearings as counsel and as arbitrator. And I think it's really a matter of working very hard, trying to be, of course, creative, being particularly when you're a counsel, but as well sometimes as an arbitrator you have to be creative. And I think, I think the main recipe is working hard. That would be my conclusion.
What about, I guess, qualities such as honesty or honorableness?
I think honesty is absolutely fundamental. I think the ethics is very, very important. And I think it's something which I have put very high in the list in our firm. I mean, everybody can make a mistake, and we all lawyers have made mistakes, but unethical behaviors are not tolerated, and I think, and particularly when you live in countries where corruption is prevalent, and you have to be particularly strict. And I think having an honest professional career pays off, and clearly it can be achieved. And sometimes countries such, unfortunately, where corruption is, I think corruption exists all over the world, but in some countries it's higher because simply enforcement is not as it should be. But I think the ethical part is absolutely crucial.
How has the practice of law changed since you started your career?
Drastically. I think technology has completely changed the profession. I think for good and for bad. For good in that, of course, we are much more efficient. I mean, with technology, computers, internet. But on the other hand, I think everything is going so quick that in the old time, we had more time to reflect. The old time, we had not even electrical type machines when I started my career. You had not even fax or telex or everything what came later. And today technology is completely changed. Arbitration is changing arbitration. And I think there's a big shift. I think in the old days, you didn't have the same pressure. You received the contract from a client by mail, which sometimes took a month. So you reviewed the contract. Telephone was very expensive, so you had the call was 3 minutes, because it was very expensive. And so your secretary typed the thing again, and then you put it in an envelope, and it took 3 months, the process when it came, doing the revision, but you had time. I mean, you could reflect. And we did arbitration when I was sitting at the court starting in '82. A request for arbitration, or a memorial, not a request, a memorial, was 20, 30 pages. I mean, the awards were, and a long award was 50 pages. Today, there's no award less than 50 pages. And I think with copy-paste, I mean, everything becomes longer. In the old days, we were able to do things more concrete. Of course, you had the tools of the footnotes and all that didn't exist. I mean, it would have been impossible to do a long memorial because the secretary had to type the whole thing. You corrected one page, you had to type it again. So it changed. And of course, I love the technology because you can practice wherever you are. You can answer your emails when you're at a conference. You can have a conference call. You can have your computer. So you can have your office wherever you want in the world. So that being able to move is fantastic. But I think we have exaggerated with the technology, and it has changed dramatically, I would say. And it's still, we haven't finished. I mean, it's still, we're in the evolution.
I won't say how many people I saw looking shamefaced when he talked about copy pasting. I can see all of you. Have you ever doubted that the practice of law was the right career for you? No.
I love my profession. I've never doubted it 1 second. And if I would reincarnate again, I would probably study law again because I love the profession. I think it's the most fascinating area, and particularly international arbitration. Knowing all the people from all the world and having friends all over the world is something which was great. And I like the idea of international law, but I had no idea exactly where it would go, if I would go to public international law. And then I am in international public law in investor-state arbitration, which sometimes when I was young, I thought a judge at the court, the ICJ and stuff like that, and I ended up with something I love, which I would not like to change.
So what do you predict for the future of investor-state arbitration?
I think investor-state arbitration will continue. I think it's under criticism. Governments have invented new methods. I don't think they will work. That's what I predict. I think that the permanent court system is not going to be efficient. I don't think they will attract the best people. I think the governments being the ones picking those judges and appellate judges, I cannot imagine how they can convince somebody with a retainer of 2,000 euros a month to be a judge and be open to receive whatever case. I mean, you have to be available 100%. So who is available 100% of the time? And I don't think they will get the best. I think that system will fail. And that's my prediction. And I think investor-state arbitration needs to correct a few things, and they can be corrected. But I think criticism has been exaggerated by many people that do not understand the system. And I think the system is not perfect, but is being perfected. And this morning we heard a conference, the Lauder president, and how this is being corrected. So the defects will be corrected, but until we don't discover something better, and I don't think that going back to diplomatic protection, some treaties have simply excluded investor-state arbitration. They leave it to arbitration between states, and simply to put together the appointments of judges of third countries. How will they agree on those? If NAFTA Chapter 20, which is a state-to-state investment between the NAFTA countries, in 24 years they have not, or 20 whatever,
Yeah.
years since NAFTA was enacted, they have not been able to put the list together. So I do not think that they will be easily find a compromise on who will be the judges on those lists. So I'm very skeptical, and I think investor state arbitration will still is the best method, in my opinion, and I think it will prevail. And we have 3,000 treaties which include it. So I don't think the whole thing will be dismantled, and I think the European Union needs to look more closely on what they are doing, because they cannot forget the investors from Europe abroad, that they need protection.
Well, thank you. I'm afraid that is all we have time for today. So I'd like to recognize David Wynn and Krishan Johnson of the ITA for helping to make this event happen. And please join me in giving Klaus a round of applause. Thank you.